Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the civil docket for Tuesday, April 28th, 2026. Court is now in session. Assisting us today are Cecilia Rodriguez, court administrator and interpreter. Ms. Gloria Noriega is the court coordinator. Video conference co-hosts this afternoon include Ms. Reyes, Mr. Lopez, Mr. Cordova, Ms. Noriega, Ms. Cuellar, Ms. Rivera, Ms. Lozano, and Mr. Hernandez. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. I don't see anyone online, so I will not give those instructions. All right, present are Ms. Claudia Garcia. She is present in person. She is counsel for plaintiff, the Kircher Apartments. To your right is
Mr. Tomas Cantu, Jr., Judge.
Mr. Cantu is noted as present in person. To Ms. Garcia's right, also present is Ms. Guadalupe Canales. She is in person. A lawyer for Alfredo Montemayor, who is also present in person, and to her right. All persons are present. Two housekeeping matters before we begin. We'll go till at least an hour, and then we'll continue if necessary. Well, it won't be, but it may. The court took some time to review the record as to the documents that had been both presented to the court and admitted with or without objection. So I'm going to put that on the record. I suggest you all write them down. If you have any issues, you can certainly revisit them in the future. And the reason I do this, so that on the record, I am right now going to re-enumerate all of the exhibits so they are sequential from 1 to 8. So exhibit 1 that was admitted was A34, a letter. Exhibit 2, and these are the renumerations. Exhibit 2 is A43 to A44, a letter. Exhibit 3 is A28 to A29, a letter. Exhibit 4 is A9 to A21, the lease contract. Exhibit 5, A975 to A1014, the lease violation. Exhibit 6 is A1015 to A1016. It's a picture of handing the letter over. Exhibit 7 is A1017. It's a post office receipt. And Exhibit 8 is A26 to A27, copies of the House rules. Those are the exhibits that have been presented to the court, authenticated, and admitted with or without an objection. If anybody has any questions on that, we can revisit that at the end. The last thing that the court will address by way of housekeeping, when last we left off, Ms. Canales, on behalf of Mr. Montemayor, requested accommodations. Day 2 of a trial, and the court had not been given any request, formally or informally, writing or otherwise, of any accommodation. So I ordered that they just be put in writing. They were filed with the court were filed with the court April 24th. There are 6 requests, and I'll take those in order. The first request is that Mr. Montemayor be allowed to complete his answer before any objection is lodged against his testimony. I'm not going to allow that because that's something that is afforded to all persons. So it's not an accommodation. That just goes, that's true for everyone. So I find that really isn't applicable. Number 2 is that he be allowed to continue testifying from his seat. I agree. Number 3 is that Mr. Montemayor be allowed to review the exhibits on paper printed form during his testimony. I'll agree at this point. Whoever wants to offer that can print it out and provide it to him. That's counsel's responsibility. So if you want to do that from now on, absolutely, I agree. Whoever's presenting that document should do that. Number 4 is that Mr. Rodriguez be allowed to take breaks as needed to avoid mental and physical fatigue. That is agreed. I agree with that. It's so ordered. 5 is that he requests a trash can be placed next to him at the table. I think that's a good request. Has that been done? Court will take notice that the bailiff is now making that accommodation. It is so ordered. And the last one, number 6, is that he welcomes any request that he repeat his testimony if someone does not understand him. I agree, but I think that has to happen at the moment somebody requests it. In other words, we do that for every person, and that will be and continue to be true for Mr. Rodriguez. If someone doesn't understand his response, whoever that person is has a duty to speak up and say that wasn't clear, but whoever has that objection should lodge it at that time. All right, Ms. Garcia, this is not your witness. This is Ms. Canales' witness. Ms. Canales, are you ready to go forward?
Yes.
Ms. Garcia, are you ready?
Yes, sir.
All right, when last we left off, Ms. Canales, I believe you were on direct examination of your client, Mr. Montemayor?
And when?
Direct examination of your client?
Yes, I'm sorry, yes.
All right, you may proceed. Go ahead. Mr. Montemayor, you continue to be under oath, so just listen to your client's questions and we'll continue. Go ahead, Ms. Canales.
Mr. Montemayor, can you tell us what your income is right now?
I think it's 17.5 a month.
Is that
So I have the duty to speak up now. Say that response once more.
17.5
Go ahead, Ms. Canales.
a month.
1747?
17. 1.45.
1,725.
1.345.
Mic, please.
Mr. Montemayor, put your mouth as close to the microphone as possible. Go ahead.
So is it true that you get that money as Social Security disability payments?
Objection
Yes.
leading.
The court had ruled on that in writing, and the court saw that the rules of evidence allow for it. So I have ruled on that in writing. So it is overruled. You may lead.
Can you explain your disabilities that were considered before the Social Security Administration awarded you disability payments?
I'm going to object to relevance, Judge. The issue here is eviction, not at issue for the court. There's no reason for the court to consider his eligibility for financial help. It's actually obvious because he is a resident at federal housing, and he wouldn't be able to live there if he did not have federal assistance.
I understand the objection, Ms. Canales. What is the response to relevance regarding?
Your Honor, my client wants to testify as to the extent of his disabilities. He is 64 years old. He would not have qualified for Social Security benefits unless he was disabled. He will be able to testify as to his disability regarding throat, his problem with the throat, speech, what he has to go through on a daily basis to be able to eat. The fact that he's not able to talk well is in direct dispute to some of the testimony that's been presented by the witnesses.
So let's assume all of that is true. And I don't know that counsel would ever stipulate to that, but let's assume for a second that all of that is true. How does that impact the decision the court has to make, if at all?
He needs to prove that he's disabled, and he should have been given consideration because of disabilities under the Fair Housing Act, under a slew of federal regulations. He was never,
Well, but let's assume that now. Let's assume that he is disabled and he wasn't accommodated. What impact would that have on this court's ruling?
with Social Security.
The ruling, let's assume you're right. Let's assume you're 100% right and you get it in evidence and testimony. How does that impact the ruling that this court would make?
The court, we're gonna be asking the court to rule that he was not extended any consideration for an accommodation because of disabilities.
But let's assume that's right, and I think that's the court's point. Let's assume you're right. Assuming that nothing changes, if they prevail on their claim and you prove that, is that really a defense?
You know, federal regulations spell out that anytime a federally subsidized housing project denies a disabled tenant the right to live there with some accommodations, and if that doesn't happen, if there's no accommodation, then there's no reason for the housing authority or the housing complex to evict Mr. Montemayor. Any violation of a disabled tenant's rights to remain there with some accommodation.
All right, at this time, the court finds the objection should be sustained because there is no evidence in the there is no evidence in the record at this juncture with the plaintiff having rested that the basis of the eviction is anything related to disability. The objection is sustained. You may ask your next question.
Can you, Mr. Montemayor, can you explain what is it, what are your physical limitations for disability?
Your Honor, can I answer that?
There is no objection. You may answer.
Well, my disability is polite. My speech, my balance, my being able to do a lot of things for myself. I mean, attending to my daily chores is part of my therapy, but to other people it's like, I can deny you all those privileges and not allow you to have anything, So that's the way I've been living there the whole time. I'm not allowed to do this, I'm not allowed to do that. Supposedly, I'm not allowed to sit outside. It's like they tell me I'm supposed to be in prison inside my house.
Your Honor, I'm going to object to the non-responsiveness of the question after he explained his physical disabilities.
Sustained. Next question.
Mr. Montemayor, we have witnessed you clearing your throat and spitting. Do you have any disability tied to your throat?
Your Honor, I'm going to object because describing disabilities, with all due respect, has nothing to do with the likelihood or the dislikelihood that he violated the terms of the lease agreement for which we seek eviction. And I just don't want the issues to get confused with regard to the standard that my client needs to meet in order to prevail on this application for eviction, Judge.
Any response?
Your Honor, we have heard testimony from fellow tenants who have said that Mr. Montemayor has been aggressive, has screamed, has yelled. That is not possible. Mr. Montemayor cannot scream or yell or be aggressive because of his throat condition. And we need to present that information for forward so that the court can make a decision with all consideration of the extent of his disabilities.
Well, what an interesting predicament y'all put in. So on the one hand, the court would like to sustain the objection because it really isn't a defense per se. It's not certainly an absolute defense. If true, as to the allegations testified to by the other tenants. However, if you are, and if I'm hearing you correct, Ms. Canales, it sounds like you're offering the testimony to rebut their credibility. I think you're allowed to do that. So with that limitation overruled, and you may proceed with that limitation or with that understanding.
Can you answer the question about your throat?
Judge, permission to speak.
Yes, sir, go ahead.
Yes, I mean, stop and think a while. How can these people portray me as violent, as a person that screams, causes all this negative stuff? I mean, Ms. Garcia is trying to stamp me as a terrorist, supposedly go around terrorizing everybody in the complex. I don't even leave my room, mostly. So, how can any of this be true? I mean, for the most part, I agree as disliking of my person by all these people, because one thing about me they don't like. Again, Ms. Garcia keeps attacking me when really you're barking at the wrong tree. You say you look out for the best interest of the owners of the complex. Well, maybe you should be investigating the person that runs it. Because and do your job and investigate. Don't be pushing everything they tell you. You haven't done an investigation. You're just pushing everything they tell you.
Ms. Canales.
Your Honor, I'm going to object again to the non-responsiveness with regard to the rest of the testimony following his testimony about his throat condition.
Sustained.
Mr. Montemayor, what happens if you raise your voice when you, for example, when you scream? How do you feel? How does your throat react?
I'm surprised I've been able to speak that much so far, because if I push myself, I might cause myself to start choking or coughing or,
Do you feel pain?
no. This whole drama has been causing me a lot of stress, anxiety, but they don't care.
Do you have any other physical illnesses that you haven't told the court?
Well, as far as my balance and not being able to walk, I mean, when I got there, I could still walk, but I had knowledge, so now I haven't been able to get out of my chair just yet. I mean, I learned to walk and talk 3 times already. I'm still working on my 4th time.
When you, just to get an idea of your routine on a good day when there's no rain, can you just briefly tell us what your day's activities are like? What do you do?
Well,
I'm going to object to the relevance, Judge.
Relevance on routine.
Mr. Montemayor has hobbies that are related to his garden. He gardens as a way to spend his time and
Overruled, you may answer.
go ahead.
Oh, yes, I've always said that my garden, my daily chores are part of my therapy, but for the same reason, I always get the same response. I don't need to allow you to have any plans or do anything. I can deny you everything. I meaning is like, they don't care. They claim to care, but no.
I'm going to object to non-responsiveness after he explained that he likes to garden.
Sustained.
Mr. Montemayor, you heard the testimony offered by Mr. Huerta. Do you want to explain your side of the story on that?
You want to may
You may.
Okay, let me try and draw you a picture here. You know how every lawnmower has an exhaust where it shoots out the sleepers.
I can hear you, Mr. Montemayor, but
Yeah,
I
you get
really
your
need that
cap out.
microphone to be right up
This-
against
this
your mouth
is
as
what
close
I'm
as
gonna
possible.
use.
You may continue.
This is what I'm gonna use to show you my picture. Picture this as a lawnmower. This is the exhaust of the lawnmower. Why will you go in front of my room when the lawnmower is shooting the sleeping towards me? Instead of turning around and doing a lawnmower like that, where he shoots it away from me, he never does that. And and then he say, you gotta get inside because you might get hurt. And then he don't look, points the lawnmower or the blower. He's done it several times. And I got my own gardener ever since the first time he did it. He took out my Christmas lights with a wind in it. He broke the wires. Did he report or did anybody reimburse me for the lights? Of course not. It's me. So nobody said nothing about that.
Have you, did you complain to management regarding that incident with Mr. Huerta?
For purposes of the record, before you answer that question, I'm going to put on the record that the court has seen Mr. Montemayor use his brown-colored baseball cap as a method of depicting the location of the lawnmower of the situation he was describing. It's clear to the court. There has been no clarification other than what I've just put on the record. Mr. Montemayor, you may answer that next question. Go ahead.
What was the question?
Uh, did you complain about Mr. Huerta's behavior with any person at the office, at the manager's office?
Well, the thing is, it doesn't matter. Don't want to hear my complaints. Like Mr. Cantu here has told me several times, because sometimes a neighbor might complain and a minute later they're in my door. And then if I say, well, they do that all the time, and the normal response I get from him all the time is like, well, maybe you need a house somewhere else where you can be comfortable. They never do anything about it, so it doesn't, I can't be complaining about everything all the time. They're not gonna do anything about it anyway.
How many times did Mr. Cantu tell you that?
Oh, I can even come. Let me show you. I reported the stove. So
Into the
many,
microphone.
I reported the stove so many times. He never fixed it. And yesterday making my breakfast. I got bread. Does she care? Is he gonna fix it now? Probably not.
After what? Object after what now?
Counsel is inaudible. Her microphone is not on.
I'm sorry. I'm gonna object to non-responsiveness following Mr. Montemayor's response regarding what did Mr. Cantu do about it when he went on to a narrative of other situations that have nothing to do with this case.
Sustained.
Mr. Montemayor, you heard testimony by Mr. Mata, Jose Luis Mata. Do you remember the testimony? And do you have any kind of reply about that?
Permission to elaborate. Permission to elaborate on the response.
Yes, I mean, unless, I'm sorry.
Look, so you've seen counsel now object and get sustained to several narrative responses. The only thing that I can suggest and perhaps even instruct you to do is just listen to the question as being asked by your lawyer, answer that specific question because she's trying really hard to keep you within the bounds where your question can come in evidence. So listen to the question once more, and then you can answer that question. Ms. Canales, go ahead.
What did, do you have anything, or what can you, remember that you, how you responded to Mr. Mata when he discussed that, that incident about you and your behavior toward him and his wife?
One Johnson is not true because let me coach on what to say, what to complain. How many times have I seen them go and lock themselves up at my neighbor's apartment to coach them on what to say, what to complain? Like the other day, Ms. Garcia, every time she asks a question, do you agree that it makes you feel sick and at the same time, she's going like, this is what I need to understand.
Ms. Canales.
I'm sorry, I was just waiting to see if Mr. Montemayor was done. I'm gonna object to the non-responsiveness with regard to the narrative following whether or not he believes Mr. and Mrs. Mata were truthful.
Sister.
Mr. Montemayor, if you can answer the question asked without having to to try and discuss things that are not related to the question, or I know you have the urge to talk and explain everything you've been held back on. But we can move faster if you can get information based on the question I'm asking, and everything's gonna come out, hopefully. But for now, can you explain your reaction to Mr. Mata's complaint about you?
What we said is not true. I mean, just the mere fact that they say that my mere existence makes them feel bad. It affects their health, get serious. I mean, I might be too ugly, I guess, that it can affect their health, really seeing me outside. I mean, really, if that happens, why is it that every time I'm about to go outside. I look around and there's nobody outside. The moment I step outside, there he comes. And he complains about this and that. Well, why do you go outside when I'm outside? That's pretty simple.
Ms. Canales?
Do you remember that he accused you of spraying water from his garden hose toward him?
That's
wife?
not true. Our manager is here right now. Every time she steps onto the project, she's got the phone on her. Yet the other day, she testified that I dredged him with my hose. So where's the phone? I mean, really? I mean, if I dredge somebody, there's gotta be a phone or something.
Did you get a? Well, that was regarding Mr. Mata and his wife, Maria Mata, I believe, regarding an incident, on what is it, regarding Ms. Vega. She's the lady who, as you may remember, who testified that you knocked on her door at 6 o'clock in the morning, had loud music, wanted to go in. Any response to her complaint?
Yes, that never happened because, yes, I listen to my radio in the morning, but every day there's a show on the radio station 100.5 called La Ley, and it starts at 6. Every morning I will turn it on and listen to a program, and I go outside and water my plants with the door open so I can hear the radio. But at 5 in the morning, I get serious. That never happened.
So you were given a, what is that, a lease violation, I understand? Uh, and to continue with other testimony from other, well, as to Ms. Vega, is that the only time that she complained about you that you remember?
Objection calls for speculation. He can't possibly know every single time that she has complained, and she testified that she complained verbally many times.
Sustained, don't guess, don't speculate. If you want to be specific with the questions, you may. Next question.
Regarding the incident, that you were given a notice of a lease violation for your, I guess, the way you communicated with some employees from Trashco. Do you have anything? They were saying that you, I guess, used foul language against them, and you didn't go to the manager's office first before dealing with any complaints. Would you like to explain any of that regarding anything regarding that incident?
Again, Your Honor, that never happened. I mean, yes, I did call Transco because they got a phone number printed on the dumpster. And I called them because the dumpster was already overflowing. And the tenants weren't throwing the bags on top of the dumpster. They were just throwing them there. And they're not healthy for anybody. And did I get a thank you for calling or doing this instead of them moving a finger? Of course not. On the contrary, I got shoot at.
Did the company complain to you directly?
No, I guess they already trained. Instead of doing what I asked, they called the office and they told them, you got a tenant calling us to go pick up the dumpster. And it's not till Wednesday. So I guess they get charged an extra pickup, which he couldn't handle. Immediately I got a write-up for calling them those companies. Like they say, I'm nobody there to be doing anything like that. They don't do it. I mean, I'm over there picking up dirty pampers, trash bags, and the whole thing covering potholes, buying material out of my own pocket. The $3, of course.
Your Honor, I'm going to I'm going to object to the non-responsiveness after he described and denied the allegations with regard to Trashco.
Sustained.
You heard testimony from Ms. Arriaga, the assistant to Mr. Cantu, regarding I guess the different violations that were issued against you. Would you like to explain anything regarding her testimony that you feel was not correct?
Well, just the fact that this is a fact, Judge, Your Honor. Joanna Arriaga has actually tried to turn my provider against me because I sent my provider with the rent money or whatever to the office, and I can tell you one time when she went, "Are you okay?" The neighbor called that you were screaming, like trying to make up a story that never happened. But that's the way they do things around there.
Your Honor, I'm going to object to the non-responsiveness of Mr. Montemayor's answer.
Sustained. Ms. Canales.
Mr. Montemayor, were you ever, do you remember the last time? Let me start over again. Do you remember the last time that you were called to the manager's office to fill out or to give him information required for continued residency there or recertification?
I'm going to object to relevance, Judge.
What is the relevance to this question, Ms. Canales?
He was called to the office, I guess, every year residents have to reapply. And so they can, I guess, so that the housing complex can determine whether they continue to be eligible for housing. At that time, he was extended tenancy, even though all these incidents had transpired, and yet he was called every year to reapply and be recertified, and he continued to live there. And anytime that under a contract, if there's incidents of breach of a contract, once that contract is renewed, then the party cannot complain about violations of the contract if they continue to certify. I mean, he had a contract, a housing contract. You had to behave. You had to these are the rules, and so he allegedly broke some rules, and yet.
I guess I just want to make sure that I understand.
Pardon?
I want to make sure that I understand the argument. Is it then your position that the complex could have just not certified and circumvented an eviction process altogether?
Well, they could have, they could have began eviction proceedings. I mean, actually, by not bringing up.
My question is, did they have the option not to certify and completely circumvent an eviction proceeding?
I understand that they do, but I'm sorry, go ahead.
No, I'm listening.
That anytime a contract is renewed, they cannot complain about incidents that happened before the contract was renewed. There's the theory of waiver. They waive the housing complex, waive its rights to complain about
Well,
behavior.
I tell you what, I'm gonna allow you to elicit some questions factually on that, but you're gonna have to tie it up legally, because I don't know that that is or isn't true legally. You see what I'm saying? So I'll allow you a few questions and then tie it up somehow. In other words, he can testify as to the facts, but you're gonna have to tell the court what law or what legal theories apply. He can't do that, but go ahead.
Your Honor, if I respect the judges, your Honor's ruling, but I just need to put on the record that, Ms. Canales' description, is completely false and fictional. I will recall my client to explain all this so that the court will understand that this is a non-issue and irrelevant to the eviction.
Well, I don't know
my
that
client's
the reason,
position-
so the reason I'm allowing the testimony is because I don't think anybody's going to dispute the facts. I think you all are there on the facts. So it doesn't matter if true that everybody agrees to the facts. You're gonna, both of you, each of you are gonna have to convince this court that you're right on the law, because I still have the question. If all of this could have been circumvented, and I don't know that you can circumvent Texas eviction law, then why go through the whole certification process? We can just do that. But that isn't something for me to answer right now. It's for you all to convince the court that your position is correct, each and both. So get to the facts, and then we can focus on the law once you conclude. Ms. Canales, go ahead.
Mr. Montemayor, how many times have you been sued by your landlord for eviction besides the current case that we're in right now? Was there another time that they hauled you into JP court to kick you out?
No,
And did they ever have conversations with you? Did anybody in the manager's office meet with you to tell you if you break certain rules, you may be evicted?
yes, several times for them, non-violent complaints like having my broom outside, having my mop outside, having a chair outside. Every time I got written up for something, they would come in to threaten me. One more of those and you're out. One more of those and you're out. All the time.
Mr. Montemayor, have you been accused of not paying the rent on time, for example?
Objection, relevance. There is no allegation that the eviction is based on non-payment of rent.
Sustained. Next question.
Other than the accusations that several of the tenants have lodged against you, or let me rephrase that. Have you been, before this episode, before the current case, have you been given a paper saying, or any kind of a notice from the main office saying, if you continue to yell obscenities at people, if you continue to wet people's feet, you will be evicted?
Objection to the form of the question, Judge. It's assuming facts not in evidence.
Sustained.
Have you ever been told that you could be evicted based on the complaints from your fellow co-tenants?
They haven't told me, but I'm sure they told my neighbors because they keep making up stories and all this.
I have no questions right now. I can.
Cross-examination, Ms. Garcia.
Yes. I'm going to refer to Exhibit 5, renumbered. And I have a copy that I'm going to present to Mr. Montemayor, if it is okay that I approach him, Judge.
You may.
May I have a microphone?
Court staff will provide a microphone for audio.
Mr. Montemayor, I'm going to put in front of you a document that is already in evidence in this case, okay? And I am going to turn to page. Get to that page.
What's the title of the document?
It is the, let me give you the Bates stamp numbers. It is A975 to A1014. It is the March 20th, 2026 termination. It's already in evidence. And I'm referring to exhibit. I'm sorry, I'm getting that. Exhibit 1 attached, which is on page A983 for the record. Mr. Montemayor, you testified a little while ago that you were never notified of any incidents in which, if you repeat the behavior, you could be evicted later on. Is that true?
It's true that every time they complain about something I did, yeah, they will tell me that I could be a victim.
Okay,
One more and you're out. One more and you're out.
okay.
One more and you're out every time.
Does this document say that, give the date? I'm sorry, I'm just gonna look at it. May 1st, 2021. Where I'm pointing, and let the record reflect, I'm pointing to the date on page A983.
One.
Do you agree that that's May 1st, 2021?
Mm,
And do you agree that it is addressed to you, Mr. Alfredo Montemayor?
mm.
Okay. Now, do you agree that down here, if I may get closer, Judge, I can't read backwards.
You may.
I'm going to read where it says complaint so that it's easier for you to understand, okay? In the middle of the page, it says complaint. On April 28th, 2021, our office received a complaint about you calling and harassing the office staff at Trashco. Please be advised that it is our office responsibility to contact any company we hire to do maintenance or service to our property, and not the tenant's responsibility to be calling. We ask that in the future, if you should have any concerns or complaints, to report directly to the office manager, Sylvia Fuentes, correct? And then it says violations, house rules. Number 9, tenants are responsible for the conduct, damages caused by tenants or violations in our area, or visitors in our area. And then number 28, tenants are responsible to call the office to report any problem or damage to create a work order. Do you see that? Do you agree that that's what it says? And so then it says lease agreement, page 3 of 10, section 9D. And then it lists the HUD handbook, material noncompliance with the lease. And it's telling you what repeated minor violations are. Repeated minor violations that disrupt the livability of the property, adversely affects the health or safety of any person or the right of any tenant to peacefully enjoy the property, interfere with the management of the property, or have adverse financial effects of the property. Do you agree that's what it says?
I agree, that's what it says,
Okay, thank you.
but that,
Okay.
does that apply to you people too? Because you guys keep disrupting the livability of myself. I mean, the overflowing of the dumpster is not healthy for anybody living there. And other tenants come to me and I keep telling them I'm not nobody there. I complain to the office, but this guy got everybody under threat that they don't even have the courage to complain about anything because they don't want to get in the unwanted list.
I'm gonna object to the non-responsiveness after he agreed that that is correctly read, Judge.
And I also
Su-
wanna
Sustained. Next
complain-
question.
I also want to complain that
Sustained. And Ms. Garcia, would you put on the record the next question, please?
Yes. And on page A984, it gives you examples of minor violations, correct? Tenant behaves or acts in a manner that continuously disrupts the rights of other residents to enjoy the property. Did I read that correctly?
um,
Examples of minor violations. Tenant behaves or acts in a manner that continuously disrupts the rights of other residents to enjoy the property. Did I read that correctly?
yeah,
Can you closer to the microphone, please?
I guess,
Okay, and this is your signature down here, tenant, correct?
yeah,
So you did receive this notice,
I guess.
this lease termination notice, okay. Then I'm going to refer you to Exhibit 2, page A986. Do you see that number right here?
Mhm.
Do you see the date? 10/12/2021.
Yes.
And it says tenant's name, Alfredo Montemayor, correct?
Yes.
And in the middle of the page, it says no compliance of house rules, and they cite House Rule 22, correct?
Mm.
And right underneath it says note, violations are classified as I'm sorry, let me reread that. Note, violations are described as material noncompliance or classified as a minor violation. Repeated minor violation constitutes cause for eviction, correct? That's what it says?
Mm.
And this is your signature at the bottom where it says tenant dated October 12th, 2021, correct?
Yes.
Okay, so you did receive notice of this alleged violation, correct?
I guess.
And it did tell you that this violation is classified as material noncompliance, correct?
I guess.
Okay, thank you. Then I'm gonna go to Exhibit 3 on page 8988. Do you agree with me that the date is January 18th, 2023?
Yes.
And the tenant is you, Alfredo Montemayor, correct?
Yes.
And down here,
Mm.
it says material noncompliance with the lease, and it cites house rules that you allegedly violated, correct? Are you ready? Okay. So as I was asking, this notice dated January 18th, 2023 on page A988 says, alleges that you violated House Rules 6 and 7, 11 and 16, correct? That's what it says.
That's what it says.
Okay. And it does say, it says
I'm
note.
not saying that I did.
Okay,
That's what it says.
okay. So you do agree with me? I'm going to take my seat now, Judge. You do agree with me that in writing, you received at least 3 notifications that the behavior that you were engaging in constitute minor violations that could lead to eviction in the future, correct?
No,
You still deny it?
I didn't.
Okay. Now, you did admit that the situation with Maria Vega in 2024, you liked La Ley at 6 o'clock in the morning, correct?
At 6 o'clock.
And you do admit that you turn it on every single morning so that you go outside and water your plants.
Water my plants, work on my plants. And on many times I've asked Ms. Vega, does my noise bother you? And she, every time she responded, no, man, ni la oigo, estoy sorda.
Translation.
In English, she says, no, I can't even hear. I hard of hearing.
Witness has translated his own statement. If there's no objection, it'll stand on the record. Next question.
But you do admit that you put it on loud at 6 o'clock in the morning, correct?
Well, not too
Yes or
loud.
no?
It's not too loud.
You don't believe it's too loud.
No.
Okay, but you do turn it on every single morning.
I used to. It's been 2 years that I don't, cause I don't even have a stereo anymore.
But you did for a long
I
time.
got rid of it.
And
Inaudible. Last part of the answer was inaudible.
Restate the last part of your statement or response, Mr. Montemayor.
I got rid of the stereo a long time ago. Ever since that complaint, I got rid of the stereo. I don't even have a stereo anymore.
when did you suffer your latest stroke that made you completely unable to stand up from your wheelchair?
3 years ago,
What year was,
I guess, in May 2022, 2020, something like that.
okay, but before you could stand? Correct?
I managed. I used to ride my bike and stuff, but my balance was not completely there. I had to use the walker to get around.
But you could stand up from your wheelchair, correct?
I managed.
Okay. I'll
Before
pass-
we continue, council, please use the mic on the table.
Yes, I apologize if there was any interference. I'll pass the witness.
Ms. Canales, anything on redirect?
Yes.
Go ahead. Oh. I'm not gonna hold you to this, but I just do need an answer. Ms. Canales, do you think your redirect will last more than 10 minutes?
Do I what?
Do you think your redirect will last more than 10 minutes? More or less? I just need to know whether to break now or just wait until you're done redirecting.
I have just a brief questions
Go ahead.
about each of the items that she brought up.
We'll go for 10 minutes. Go ahead.
Regarding. Unless there's, do you want to take a break or anything? No. As to exhibit number 1. Where I'm gonna show it to you again, it's the letter lease termination notice of what is it, May 1st?
Can you please identify the bait stamp number, please?
It's exhibit 1 out of exhibit number 8 that I was, I guess, admitted into. It's a letter that you just showed him right now.
Yes, I just want the number, the page number with the case lines for the record.
What I have in this, on this paper, it just, the Bates number is 0047.
Just for purpose of the record, exhibit number 1 has case center number A34. Ms. Canales, go ahead.
I have okay. All these letters are, of course, part of exhibit 5. That's the March 20th, 2026 notice of termination. And as part of that packet, there's the letter dated May 1st, 2021. And I'm gonna ask Mr. Montemayor whether he was given the second page of that, it gives him examples of minor violation that would amount to a tenant behaving in a way that continuously disrupts the rights of other residents to enjoy the property. Mr. Montemayor, were you ever told what specific behavior would disrupt the rights of other residents? Were you told, like, do not do certain things that would disrupt? You were never told, for example,
No,
you cannot be, doing, driving your minivan at 70 miles an hour in the common areas, the parking lot? Were you told you cannot point guns at people? Were you told you cannot stop paying the rent for no good reason?
Your Honor, I'm going to object to the line of questioning because nothing that she's referencing has been alleged by any witness here.
Sustained. Next question.
Mr. Montemayor, on the next letter that you were shown, and that's exhibit 2, the letter dated October 12th, 2021. Is that your signature at the bottom?
yes,
And there's language halfway down after non-compliance of house rule. There's a note that says violations are classified as material non-compliance or classified as a minor violation. Do you know what the words material non-compliance means?
well, not compliance, yes. Material, I don't know what they mean by that.
Did somebody tell you what would amount to a material non-compliance of the lease?
No,
On the next exhibit, that's exhibit number 3. And this is a lease violation notice, non-compliance of house rule dated January 18th, 2023. Again, there's a, halfway down that letter, there's some terminology, and again, material, you were told that there was material non-compliance with the lease. Again, was that explained to you how your behavior was material non-compliance with the lease?
no, you wasn't. That's the way it happens all the time. They show up with a paper and they just tell you, I need you to sign here. And that's it. And I sign just to get him out. Just to get him to disappear because all I want is to be comfortable.
Does your signature appear at the bottom of that lease violation notice?
No,
Do you remember getting this notice?
no.
I pass the witness, Your Honor.
That was redirect. Anything on recross?
2 questions.
Go ahead.
You recall Mr. Cantu's testimony that every single time there was a written complaint against you, he went and spoke to you personally? Do you recall that testimony? Yes or no?
No,
I will represent to you that my client testified that anytime there was a written complaint against you, he went and spoke to you personally. Do you agree that he went to speak to you when people would complain to you,
Why do
complain
you-
about you?
why do you keep lying your head? I'm supposed to say yes or what?
Objection unresponsive and to
Sustained.
the argumentative nature of the response. Do you agree or disagree that Mr. Cantu
I
went to,
disagree.
let me finish my question, please, Mr. Montemayor, so that you understand my question. Do you agree or disagree that Mr. Cantu went to speak with you personally every single time there was a written complaint about you by a tenant? Yes or no?
She showed up many times. I don't know if it's one of any complaint happened or not. But he never shows up alone. He comes with all his group. Many guy, managers, and they come with a camera recording and everything.
I pass the witness, Judge.
All right, any other questions, Ms. Canales?
Yes. When you were given the notice, the lease termination notice dated May 1st, 2021, did you have a meeting with Mr. Cantu that you
No,
remember?
no,
When you were given a notice of lease termination dated October 12th, 2021, with a signature there, were you visited by Mr. Montemayor, Mr. Cantu to discuss the matter?
I can't remember.
And regarding the notice of lease termination dated January the 18th, 2023, where your signature does not appear at the bottom. Do you recall that Mr. Cantu visited you regarding that?
No, no.
Pass the witness, Your Honor.
All right, do you have any other witnesses, Ms. Canales?
Sorry, no questions, Judge. I didn't have the microphone on. I apologize.
Understood. Any other, do you have any other witnesses, Ms. Canales?
No?
Court said that there are no other witnesses. All right, then we're gonna stand at ease for an hour. We'll have lunch. I guess this will be the lunch break and we'll go straight into closing arguments. I suspect that 10 minutes should be more than sufficient for each side. We'll stand at ease for 1 hour. Welcome back to court. This is the final day of Father Ed Kircher Apartments versus Alfredo Montemayor, cause number 2025 CVD 74L2. Both counsel are present, both parties are present, or at least the defendant and the plaintiff's representative. When last we left off, I believe defense rested and both sides announced ready for final arguments. Ms. Garcia, are you ready?
Yes, sir.
Ms. Canales?
Yes, sir.
All right, so I'm gonna, with some instructions, as with all cases, Ms. Garcia, Ms. Canales, as you contemplate and give your argument, court is gonna ask that you summarize what the facts and evidence showed and how that supports what each of you are requesting on behalf of your clients. When you're ready, Ms. Garcia, you may begin.
Thank you. May it please the court, Judge. My client takes no joy or satisfaction in having to come to court to evict a tenant. As he testified, this is the first and only tenant he has attempted to evict in the last 16 years, Judge. And given the testimony of all the witnesses we have presented as a whole, and it was important to have the testimony of the tenants purposely and specifically so that the court could see for itself the dismay, the terrorism that they have suffered, because there is no other word to describe that. The way in which their entire livability is disrupted at Father Ed Kircher Apartments, being the next door neighbor to Mr. Montemayor. They are unable and feel unsafe to leave their apartment. They're confined to their apartment because of the systemic, continuous violations of Mr. Montemayor of the lease and the house rules, making it impossible for them to quietly enjoy their space. This is a federal housing project. As the court saw, these are elderly people. Mr. Montemayor is not the only person with disabilities or handicaps. This is what this property is for, Judge. And we believe that we have met the burden necessary under the HUD regulations and the lease agreement to show that not only has Mr. Montemayor violated the lease agreement, he has also disrupted the livability and quiet enjoyment of the tenants there and the community. And it's with a heavy heart that Mr. Cantu is requesting the court to grant the eviction under the law. So to summarize what the court has heard and to put it into perspective, the lease agreement is from July of 2021. Just a few months later, in October 2021, there was a first violation after the entry of that latest, the execution of that latest lease agreement, Judge, where he is in his current apartment, being next door neighbors directly to Mr. and Mrs. Mata and directly to Ms. Vega, Judge. And what the court, and there are two bases for the eviction. And that was the February 2025 violation of House Rule 16 that the court heard about. And you heard Mr. Huerta's testimony and you heard Mr. Montemayor's testimony. On that day, Mr. Huerta was trying to carry out his obligations, and he stated that this is not the first time and it wasn't the last time that Mr. Montemayor has obstructed, interfered, and interrupted his obligation to carry out maintenance. Maintenance that could cause Mr. Montemayor physical injury if he does not step back. And at this point, back in 2025, Mr. Huerta had enough and said, you know what? I need to report you now. And he got the report and he was told about the violation, Judge. And by his own admission, Mr. Montemayor testified that Mr. Huerta told him to stand back, because if not, he could be hit with debris. And Mr. Huerta told him, please go to your apartment so I can finish this out. But it's not just the interruption, it's the manner in which he goes about it as well, Judge, where he is rude and obstructive and aggressive in spite of his disabilities, Judge. And that is not controverted. Even Mr. Montemayor said that he's told him many times to stay back and to go into his home. And he had still violated that, Judge. So he has noticed that he needs to stay inside and let Mr. Huerta do his job. The second basis for today's eviction is what happened in July 2025, that Mr. and Mrs. Mata testified about being sprayed and yelled at by Mr. Montemayor. Does he have difficulty speaking? Yes, but he has no difficulty in being aggressive, taunting, and taking it as a joke to spray people of his own age, elderly people, with water, climbing stairs and holding on to a rail, Judge. Had something happened to Mr. and Mrs. Mata, it would be a different story today, and Mr. Cantu could be in court for different purposes. That kind of behavior, it's not the first time and it hasn't been the last time, and that is the testimony that Mr. and Mrs. Mata gave. It was corroborated by Ms. Arriaga, who witnessed that. She went out there, she saw it, she chastised him, she warned him, and he did it again, laughing, thumbing his nose at the authority of the management of this property. That is in violation of House Rule 11 that we have cited to the court. And the other reason why we put prior written notices of minor violations was so that there would be no question that he had been notified, at least in writing, a few times of prior violations of the lease agreement, so that there would be no question that they're counting and taking notice and keeping the file so that he cannot come back and say, I did not know. It is not a defense to say, I don't know what material noncompliance is, because by his own admission this morning, Judge, there were many times that management went to his apartment, knocked on the door, told him he was in violation of something, and if he did it again, he'd be kicked out. He said it happened over and over and over and over again. But the times that we do know that he violated the lease agreement for which we heard testimony, the most concerning one, Judge, is Ms. Vega, his next door neighbor. Mr. Montemayor freely admits he likes listening to La Ley at 6 o'clock in the morning. And Ms. Vega testified that it happens repeatedly. This is the only time she just put it in writing, Judge, in 2024. When he went to her door, knocked on her door, had the radio full blast, wetting her door, to the point where this single woman took matters into her own hands to put an extra lock and a camera on a housing authority property, Judge, so that she would feel safe. But she said she does not feel safe. She does not feel comfortable. He has disrupted the quiet enjoyment of her community, and she would prefer that he leave, Judge. And what's worse, as a woman, when she told him at that time, I'm going to report you, and his response was, go ahead. Go ahead. By the time anyone comes to help you, I will have had my way with you, regardless of his disability. A woman of her age living alone, being confronted by that threat. So if I say that he has terrorized Ms. Vega, he has terrorized Ms. Vega. Then we go to the other incidences with Mr. and Mrs. Mata. This is not the first time that he has wet them. It's not the first time that he has terrorized them. As Mr. and Mrs. Mata say, they don't leave their apartment because they are afraid of him. The instances that they gave was him getting a weed eater or lawnmower, cutting branches and throwing them all around their area where they need to pick things up, screaming and yelling at them. The radio, again, the loud noises constantly, the threats, the aggression, the laughing, the thumbing of the nose to the authority of Fred Kircher Apartments. So in the lease agreement, it says very specifically in paragraph 9B that the landlord's right to terminate this agreement is governed by the regulation of 24 CFR Part 247 HUD regulations, which is parroted in the paragraph that said that the landlord may terminate the lease agreement upon material noncompliance with this agreement. And that is defined in paragraph D. And the basis that we have notified him has been the material noncompliance with this agreement shall, in the case of tenant, include number 2, repeated minor violations of this agreement which disrupt the livability of a project, adversely affect the health or safety of any person, or the right of the tenant to the quiet enjoyment of this leased premises and related project facilities, interfere with the management of the project, or have an adverse financial effect on the project. You heard the testimony, Judge. He interfered with my client's service contract of Trashco, to the point where Trashco contacted Mr. Cantu and said, if your client continues to do this, we're gonna cut your contract. Mr. Montemayor regularly likes to spray water at Mr. and Mrs. Mata, an elderly couple. Should they slip and fall, who's gonna have that problem here? Father Ed Kircher. A bigger problem, Judge. They have all testified that they are afraid. They're unable to leave their homes because of the constant aggression by Mr. Montemayor, and it simply has to stop. We appreciate the court's direction in redoing our lease termination notice that we did and has been submitted as evidence in this case. Every single requirement of the HUD regulations, the lease agreement, the property code, and Violence Against Women Act have been complied with. That notice is solid, Judge. And for these reasons, we believe we have met the burden to show that Mr. Montemayor has violated the lease agreement, the terms of the lease agreement. He has engaged in prior minor violations of the lease agreement, which he admits by himself that he has done so. And for these reasons, Judge, we'd ask the court to grant the petition for eviction. We ask the court to provide 3 days written notice under writ of possession for Mr. Montemayor to vacate the property under the property code. I believe that's under chapter 24. And we would like an order releasing all funds on deposit in the registry of the court to be paid directly to Father Ed Kircher, because those are rent amounts that Father Ed Kircher has not received since August of 2025. Thank you.
Same comments or instructions to defense, argument, and tell the court what your client is requesting and what evidence testimony supports that position. Go ahead.
Your Honor, I guess more telling of the fact that the landlord is afraid of losing this case and their lack of confidence in winning this case is the fact that they have filed a second eviction proceeding, and Mr. Montemayor is supposed to be back in JP Court
Your Honor, I'm going to
next
object to
Wednesday
this
on
argument.
May 7th.
I don't mean to interrupt, but this is outside the perimeter of this case, Judge, and there's no testimony, no pleadings, and it's improper argument, Judge.
Interesting, but not relevant to our purpose here. Go ahead.
Mr. Montemayor has testified that he is disabled. As such, he is covered under the Fair Housing Act, the Section 504 of the Rehabilitation Act, and the Americans with Disability Act. Mr. Montemayor has lived in their, in their complex for the last 5 or 6 years, since I guess for 6 years. The violations that Mr. Montemayor faces were finally disclosed to him on February the 20th, 2026. And again, in another notice of lease termination on March 20th, 2026. Before that, we were left guessing as to what exactly were the lease violations in regards to. Mr. We filed a motion for, to ask the court to set aside this appeal, but of course, I mean, the motion to dismiss. Our complaints still stand. There was defective notice. And so we proceeded with this case. The landlord has proceeded to have tenants testify as to 5 violations within the last 5 to 6 years. And that's not repeated minor violations that would add up to being substantial or material non-compliance of the lease. They have not met the burden. They have focused the current eviction on two events, two alleged violations. One, she just testified as to February 2025 and July 2025. And also the repeated minor violations were set forth 2021, 2 in 2021, and 1 in 2026. Now, these violations were far apart. There was a violation on May 1st, 2026, and it wasn't until 4.5 years later that they decided that he also violated another lease section, and that was filed October 12th, 2021. So 4.5 years later, they filed another lease violation in January 18, 2023. Now that clearly shows that they were not concerned about Mr. Montemayor's behavior, because they would have just done away with a lot of, they might have proceeded to go forward with an eviction proceeding, but no, they just said, no, he's not that bad enough. So they let him go forward. They issued the lease violations, 5 violations in 5 years, and some were like up to 4.5 years apart. That clearly shows that he was not a threat to the tenants, that he was not that he did not violate any of the rules, that he was not a direct threat to anybody, and there was no proof at all from those testifying tenants that anybody got sick enough to go to the doctor, anybody got sick enough to go to the clinic. There were no reports of financial problems due to the alleged misconduct of my clients.
Your Honor, I'm going to
Uh,
object to the improper argument. I made objections with regard to that line of questioning, and Your Honor sustained that for irrelevant.
I do recall that, just for purposes of the record, closing argument, attorney argument isn't binding on the court. It's not evidence or testimony. So with that specification, you may proceed.
Mr. Cantu testified on the stand that Mr. Montemayor's misconduct has created a financial problem for them, but he did not specify how. And because there was no direct testimony as to that, he didn't meet the standard required to meet the good cause requirement in evicting somebody like Mr. Montemayor. Mr. Montemayor testified that he has that he requested an accommodation pursuant to the Section 504 of the Rehabilitation Act, the Fair Housing Act, and the Americans with Disability Act.
Your Honor, I'm going to object to improper argument again because he did not testify, because Your Honor did not admit such evidence. I've made objections to that, and Your Honor sustained my objections. So that is a false statement.
I don't remember the specific objections or the court's ruling, but I do know that the court did not hear any evidence on accommodations. I do recall vividly going through the request in writing and then making observations this morning. I guess just make brief argument and just keep going, move on.
Mr. Montemayor testified that because of the stroke that he suffered, he became disabled and is confined to a wheelchair. He cannot walk. His throat was affected. He cannot talk very loud. He cannot swallow. And as such, it is inconceivable. It's inconceivable that he was a direct threat to any of the tenants, that he was aggressive, that he yelled at people. It just unreal. It just no testimony that he was able to be that disruptive, even if he tried. In the past, the type of minor violations that have been acceptable in other cases were, situations where there were violations of a pet policy, unauthorized guests living in the household, not complying with recertification, fraud regarding income reporting, damage to the apartments. None of that occurred in this case. There was never any accusation against my client for failure to apply or to meet all the requirements of remaining qualified to continue living at that apartment complex. Mr. Montemayor cannot be accused of violating the welfare or the peace of the complex. He never was accused of doing wheelies in his minivan in the parking lot. He didn't fire any firecrackers. He never was accused of being a peeping Tom. He never stole from fellow tenants. He never pulled guns on staff members. None of that can ever be, cannot be made. And he always paid his rent on time. He did the best he could to state, to himself. He lives alone, has no kids. He testified that he enjoys his garden, that's his way of relaxation and relieving stress. And when he did so, and to the point where, because he didn't like Mr. or I guess the staff maintenance person, working on his yard, he hired his own yardman. All the accusations of him interfering with Mr. Who was it, the guy with Huerta, I guess, are just false. I mean, Mr. Cantu, Mr. Montemayor was in his yard while Mr. Huerta was working next door. Mr. Montemayor testified that at one point, Mr. Huerta pointed the weed eater toward him. He pointed his lawnmower toward him. And that's really hard to believe, but that's what my client is saying, that he wasn't interfering with Mr. Huerta at all. He was just giving him tips, I guess, on how to perform his work in a common area of the complex. Again, the landlord has not met its burden of proving that there was good cause in any eviction, that all these minor violations led to repeated all these repeated minor violations were not really repeated. They were only 5 in 5 years or 6 years. Mr. Montemayor continues to abide by the rules. He was never given any chances to mediate this matter. He was told that he had to just leave the apartment complex. And so whatever violations made against Mr. Montemayor are not enough to be a material non-compliance of the lease. There was never any harm done to the testifying tenants. Nobody complained of, like I mentioned, nobody complained of being sick, having to go to the doctor, taking special medications, none of the sort. Mr. Cantu has not created any financial distress to the apartment. He has not been accused of creating any damage to the apartment. And because of the testimony that he has brought forward, we feel that The landlord has no reason to be granted the right to evict Mr. Montemayor. And we're asking the court to consider denying their request for this eviction and approving our appeal and having Mr. Montemayor remain being a tenant at the apartment complex. Thank you, Your Honor.
I guess before the court rules, I just have two questions. It wasn't clear from the evidence or the testimony, and I don't remember reading anything in the court filings, but both questions, Ms. Canales, to you. The ability, I guess, or the right, or the obligation, whatever it is, for a tenant to contact the trash removal company, where does that arise?
Your Honor, there's cases out there where if a tenant's expression of freedom of expression can be affected if he's told not to contact people if it's concerning things that are affecting.
I'm trying to make sense of that. So one, there's a lot there. One, the court hasn't been provided any case law or any authority. If it's out there, this court certainly doesn't know. But the issue here, and let's not confuse those, is not the freedom of expression. You can say whatever he wants. The question here is whether he has the ability to contact a service that has a contractual obligation with the landlord, because what was told to the court in testimony was that there was a possible interference with that contract, which has nothing to do with freedom of speech. And I guess, and that's what I'm trying to figure out is there anything in the contract or any right, duty, obligation, or is there any that instance of contacting a contracted for service? Where does that come from? Or why was it raised?
Mr. Cantu, Mr. Montemayor felt compelled to call Trashco because the phone number was on the side of the truck.
I understand he felt compelled. My question is, can he do so? And if so, where? How? Where does that right come from?
Actually, anytime a tenant of a federally subsidized housing complex voices an opinion about the policies and the regulations of the housing authority or the housing complex, such conduct or speech is protected. So his calling Trashco is protected by the First Amendment.
I can't imagine that that's true. Let me move on to my second question.
Can I mention something?
You may.
Your Honor, I litigated a case, Ledesma versus the Laredo Housing Authority, and that came out, and the Court of Appeals out of San Antonio agreed with us, saying that the tenant had the right to complain about the conditions of the housing authority because that was protected speech.
In that situation, to whom was the complaint lodged with?
With fellow tenants and also a manager.
Correct. So it's a different situation. So number one, I'm going to put in the record once more that this court has not been provided any reasonable guidance or any guidance whatsoever as to what cases control. In fact, the court did its own research, and that's why the court was using that 13th Court of Appeals line of cases. Number one, I guess if the court has understood the premise the background circumstances and situation of the Ledesma case. In that situation, the speech was directed back to the landlord. Here, the question isn't if he can complain to the landlord. The question is, does he have the right to complain to third parties? And if he does, what impact does it have on this case? So it's very distinguishable. My second question was some thought, an argument, and testimony provided by defense about the lack of damages in this case. And I just want to make sure that I understand that. Is it defense's position that there should be some physical injury or medical damages before they can institute an eviction?
Well, that would be one of the bases for establishing good cause.
Is it exclusive?
Not exclusive, just one of the conditions.
All right.
May I
Uh,
please chime in on that?
Let
Judge?
me hear the full response and then you can reply. Go ahead.
So that would be our response. I mean, they would have to prove that would one of the instances how they can prove good cause by damages to an apartment, and that wasn't done in this case.
And I think that's what I needed to know. It's one of several things that they may, but they don't have to.
No, I think that the least.
No.
No,
Judge, if
I just wanted to clarify that point
it's
because
either,
it
May-
was harped on and I just wanted to make sure that I understood.
May I
Yes.
clarify, there is a separate section in the lease agreement that talks about another basis for eviction, which is good cause, which has separate and distinct steps and notices for eviction. My client is not suing for eviction with regard to good cause.
Hmm.
My client is specifically requesting eviction based on paragraph 9B and then D, material non-compliance with this agreement, not good cause.
Hmm.
Not good cause.
All right, Mr. Cantu, on behalf of Ed Kircher Apartments, Mr. Montemayor, we've now completed about three sessions, not 3 days, not 3 full days, but at least 3 hearings on this bench trial. Here's the court's decision. In cause number 2025 CVD 74L2, the court finds that it has jurisdiction over this case. This is an appeal stemming from an eviction out of the Justice of the Peace Court, I believe in precinct 4. For what it's worth, I'll put on the record that I think it was day 2 or day 3 of the testimony that the court heard from Attorney Canales, lawyer for defendant tenant Montemayor, that plaintiff's agent, Mr. Cantu, was making facial expressions. After I didn't see that. If it happened, I didn't see it. I'm not saying that it did or didn't. I just didn't see it. But after that moment, the court took extra effort to monitor the demeanor of all parties, persons present, lawyers, witnesses, and everybody present, not just the witnesses. And I think I certainly want to be respectful and not speak out of turn, but I think it's soundly safe to say, based on my reading of every person in the courtroom, that there is not a single person that is happy. I don't think anyone is glad that this is happening. And I think I can safely assume that everyone wished that it were not. No matter what the outcome is, I think that we can all at least find solace that justice is effectuated because every person, every party got a fair chance to win and everyone got their day in court, whether they are indigent or non-indigent, man or woman, able-bodied or accommodation requiring, all persons have been treated equally and equally heard, or at least given that opportunity to be equally heard. That being the case, in cause number 2025 CVD 74L2, the court finds that the facts, evidence, testimony in this case and the applicable statutory laws of the state of Texas and federal regulations support the request for eviction. It is so ordered. Ms. Garcia, how much time do you believe would be reasonable and necessary for that to happen?
What?
Your Honor, as I understand the property code, it says 3 days.
Oh, I'm gonna say that again, because I know
Oh.
that to be true, but the
Mhm.
question is, how much time do you
Oh,
believe?
I'm sorry, I apologize, I misspoke. 6 days pursuant to 24.006B. 6 days.
I'm sorry, what was
So
the
that is-
question? Post to her?
How much time would be reasonable and necessary to put in that order for this exclusion to take place? So the answer statutorily is 6 days.
Sir.
The question is, how much time do you believe would be reasonable and necessary in this situation? If different at all.
I believe 15 days would be reasonable, Judge.
Same question, Ms. Canales, given the outcome in this case, how much time do you believe would be reasonable and necessary?
Reasonable for my client to vacate?
Yes.
He doesn't want to vacate, Your Honor. We cannot even, I cannot even come up with a reasonable time limit when he has to vacate, maybe on his own. He'd like to have the opportunity perhaps to use his Section 8 voucher to move to another apartment, but I'm not sure whether that's the case here. But he
I
wants-
very respectfully need a number. I understand that this is a most difficult situation, but I have 6 days statutory, 15 days as a max. Give me something to work with so that I can best make this decision.
without admitting that that my client deserves to lose,
Right.
I don't know. I would have to ask him. I would think several months, maybe. 3, 4, 5, 6 months. He would have to go look for another place that can accommodate a disabled person, for example. Somebody who would accept his voucher.
I asked for what everyone believed would be reasonable and necessary, and I will say that to follow up on that many months request, I think it's also very safe to say that there was no reasonable evidence of any conspiracy in the situation. I think any month's request would likely cause severe disruptions in the already difficult living situations for many persons. The court found no motive from any of the witnesses for the housing complex to lie or to falsify their statements. All right, the exclusion or eviction is ordered May 8th by noon. All of the monies in the registry of the court will be paid to plaintiff. This orders are due to the court honor before.
Your Honor, I have May 18th, but I believe you want that sooner.
Well, it's
That
got to
would
come
be
in before the 8th. So
Friday.
let's say,
Friday, May 1st, Your Honor.
excuse me, I said the 8th. Hold on.
Yes, Your Honor.
Let's say the orders are due by May the 6th at noon by submission. If there's any objections, file them soon so that I can rule on them. All right, anything else on this case, Ms. Garcia?
No, sir.
Ms. Canales?
No, Your Honor.
Your Honor, if I may,
Yes.
Gil Morales from the county clerk's office. Currently the registry amount is 2,336. And we just asked for counsel and Ms. Garcia just to file the writ of possession.
right?
I do have a question. If my client desires to appeal, can the court set up an appeal bond at this time so that he can take that into consideration?
Remind the court what that procedure is. Does there first have to be a filing and then I sign off on that? I mean, it's hypothetical till it happens, and I certainly don't want to give an opinion unless there's an actual request. So why don't I do that in the interest of justice and judicial restraint? I certainly don't want to give an opinion as to what I would do if something is filed. Let me receive that filing unless Ms. Canales or Ms. Garcia, you have a different take on what should happen at this juncture.
An appeal from this court of record, I do not know what the procedure is from an appeal for an eviction from this type of court.
Yeah, so let me receive that in writing as soon as possible, Ms. Canales, because if there's some different procedure that should take place, I would like to know as soon as possible. And once you file it, I can rule on it and even do my own research as to what should happen.
A previous court has recommended the amount of the monthly rent as part of the appeal bond. That was done in my previous case.
Right.
And so that was, Judge Martinez decided that on that situation.
I'm going to say this one more time, and I'll let the record speak for itself. But as with any request, please, this goes to everyone, please give the court some definitive case law, statute, guiding principles, something that allows the court to do squarely within due bounds what the court should do. Because if case law exists out there, I can't just by osmosis take judicial notice of that. I've got to do my own analysis. So whatever the law says, please put it in writing, and I assure you it would be within those parameters. All right. I wish everyone well. We'll stand at ease for a few minutes before we commence with our family law docket.
All right. With that is
Good afternoon. Welcome to court. Please be seated. Good afternoon and welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket for Tuesday, April 28th, 2026. The time is now 2:24. Court is now in session. Assisting us today are Cesar Rodriguez, court administrator. Interpreter is Osvaldo Cuellar. Court coordinator is Ms. Cynthia Flores. Video conference co-host this afternoon include Mr. Lopez, Mr. Cordova, Ms. Noriega, Ms. Cuellar, Ms. Hernandez, Ms. Rivera, Ms. Lozano. These proceedings are being electronically recorded. The court is going to admit all at this time for the rest of the admonishments. The court continues its docket with the rest of the admonishments. For those of you joining us online, welcome. You're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person and then those online as measured by your login times. Ms. Flores.
First case, Your Honor, is page 2, number 3, Attorney Claudia Lanesta Garcia.
This is Elsa Gomez, Andres Jorge Gomez, cause number 2018 FLA 2421C3. Court marks Ms. Garcia, present in person. Edward Dancaus, I thought the court saw him present.
I did see him and Alonso Ramos present, but I looked around and I was going to go speak with them, but I haven't seen them.
Elsa Gomez, Andres Jorge Gomez, are you present? Please step forward.
I'm not sure. Mr.
Present.
Is online. Thank you.
Mr. Gomez, I'm going to ask.
I am present, Your Honor.
Are you Andres Gomez?
Yes, I am, Your Honor.
Welcome to court, Mr. Gomez. The court marks you present by video conference. As you can see and hear from your device, your lawyer is present in person. Are you Elsa Gomez? Into the microphone.
Yes, Your Honor.
Welcome to court, Ms. Gomez. The court marks you present in person. The court saw at least one of your lawyers here this afternoon. Have you had a chance to talk to them? Speak into the microphone,
Inaudible.
please.
I am so sorry, forgive me. They went to speak with someone they had subpoena.
Well, I don't know why they should be in court. Is somebody here on behalf of the Attorney General's office? All right, court marks.
Yes, Your Honor. Yes, Your Honor.
Locating your device, counsel. Mr. Gonzalez?
Yes, sir.
All right, welcome to court, Mr. Gonzalez. The court marks you present on behalf of the Attorney General's office. You're participating by video conference. Ms. Garcia, what is the announcement?
Your Honor, I did file, but it's not set for today. A motion to withdraw as counsel for Mr. Gomez. I have conferred with Mr. Gomez and he is aware.
Court marks both Mr. Ramos and Mr. Dancaus now present in person. I think this might be the first setting. I know the Attorney General's office just intervened last month. All right, so on behalf of respondent, Ms. Garcia says she's filed a motion to withdraw. It's not set for today. What say you, Mr. Ramos and Mr. Dancaus?
Good afternoon, Judge. Alonso Ramos and Mr. Dancaus present for Mrs. Gomez. I know Ms. Garcia filed a motion. I know it's not set before the court. We have no objections to it on behalf of Ms. Gomez as it relates. Yeah, we don't have objections, Judge. I will tell the court that since she got involved, I mean, I don't want her to leave, but she got involved. Good things happened as it relates to these moments. But I understand she has to get out.
Oh, she doesn't have to. The court needs to make a decision. Mr. Gomez, this matter isn't set for today. Have you had an opportunity to think about these things?
Your Honor, I was notified on Friday that Ms. Lanese was gonna withdraw and got a notice. After that, I've been actively trying to secure an additional counsel. I would respectfully request a continuance if possible, so I could do that. If because
So
of that short
it
notice.
sounds like you have had sufficient or some time, maybe not sufficient, but some time to think about these things. Two questions, Mr. Gomez, do you have any objection? Because I didn't hear an objection from Ms. Gomez's lawyers. Do you have any objection to the court considering this matter today?
Consider, again, considering the matter would be what the continuance.
Well, I'm not there yet. I mean, it really depends. Let me ask you that. I'll just ask my second question. Maybe that'll make more sense. Do you have an objection to Ms. Garcia withdrawing from this case?
Sir, I don't know what my options are. I mean,
Do you want
I
her to
don't
stay
know.
on, or do you want her to get out of the case, or is it something in between?
I personally think that she was helping me as just it was a matter of an additional retainer that was requested, which but I would want her to continue, but
All
sir,
right, for a proper notice, Ms. Flores, give us a setting on this motion to withdraw.
And how much time, Your Honor?
No.
Your Honor, I would just advise the court, I have a vacation letter beginning May 13th. Through the end of the month.
I guess the question, the proper and fair question is to you, Mr. Gomez. There's a chance, there's a chance the court could grant the motion. There's a chance the court could deny the motion. If the court grants a motion, how much time do you believe would be reasonable and necessary to look for a lawyer and hire a lawyer if, in that scenario, the court excuses Ms. Garcia?
I started yesterday trying to acquire and look for somebody. Unfortunately, it's not enough time. It hasn't been enough time. I would just grant a reasonable short amount of time to
The court's gonna
possibly.
hear this on May the 5th at 2 p.m. I mean, you don't give a definitive answer. I'm just going to plug some number in. So you have until May the 5th. Talk to Ms. Garcia if you think it's going to help. I may grant it, I may not grant it, depending on what is presented to the court. Anything else on this case, Mr. Ramos or Mr. Dancaus?
Yes, Judge, two things. We subpoenaed a witness because we're separate trial and merit stage, Judge. So we subpoenaed Mr. Gonzalez.
Closer to the mic, Mr. Allen, so you're turning your
sorry.
head away.
Yeah, Mr. Gonzalez, so we witness here, Judge, we'd like for him to be sworn in and put under the rule, and then so we can inform him when he may have to come back for trial and merit.
Well, I don't even know the answer to that. Ms. Flores, give us a final hearing date in June.
June 16th at 2 p.m.
This is only, you only have one person subpoenaed that's going to testify, Mr. Ramos?
Yeah.
Mr. Gonzalez, if you're present, please step forward.
Yes, John. The witness.
Mr. Gonzalez, step in front of a microphone, pull it as close to your mouth as possible and tell the court, what is your name?
My name is Juan Lelo Gonzalez.
Juan Gonzalez. Mr. Gonzalez, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes, sir.
Court has heard yes. You may lower your hand, Mr. Gonzalez. I'm going to reset this case for June the 16th at 2. Between now and then, don't talk to any person about this case. You are under oath. If somebody tries to talk to you about this case, you should let the court know, and you should be here right before 2 on June the 16th. Do you have any questions for the court, Mr. Gonzalez?
No, sir.
Ms. Noriega. Ms. Flores.
Would this be an in-person hearing, Your Honor?
Yes, make sure that you're present in person. Mr. Gomez, make sure that you're present in person as well. All right.
Yes, Your Honor.
Mr. Gonzalez, you're excused.
And then the second thing I want to point out, we're here on a
Before
petition,
the mic, please.
we're here on a petition for the enforcement of spousal maintenance, Judge. Just to inform the court and all parties, at the end of that hearing, we're requesting under the pleadings that I have on file to be, for Mr. Gomez to be held in contempt for violating the court's orders, and that he be placed in the jail and that bond be set for the amount of non-payment of spousal maintenance as awarded by the court.
What was the point of that comment?
Well, just to let everybody know what I'm asking, what I'm gonna be asking.
Well, don't worry
for.
about don't worry about letting anybody else know. Worry about what the court knows what you filed. So the purpose of regurgitating what you've already filed on a date that we're not going to go forward with the final hearing is what?
Well, just informing the court why, because we were set for today on trial.
But we're not going to hear it today. So what was the point of that?
I apologize, Your Honor.
It's a sincere question. It feels like at the time that Ms. Garcia is getting out, you're now addressing Mr. Gomez by saying you either comply or we're going to put you in jail. And I want to make sure that I understand the tone.
I think it was more informational, Judge, really.
I'll take judicial notice of the court file. Yeah. Anything else on this case, Mr. Dankhouse?
I would second the motion, Judge. I know that the court doesn't want to be listening to it, but
I'm
move
ready to go
forward, Judge.
today. It's not that I don't want to hear it. Ms. Garcia needs to have her hearing set. So on the day that nobody objects to properly setting this motion, I can't hear this.
Judge, it's out of courtesy that we're doing what we're doing, Judge. Not only to the court, but to Gomez.
Right.
We shouldn't be, because he's already got 2 strikes at this with your order.
I don't disagree with that, Mr. Dankhouse. Yeah.
That's all I have, Judge.
Ms. Gomez, do you have any questions for the court? Do you have any questions? Mr. Gomez, do you have any questions for the court?
No, can I make I just wanted to make an observation, a comment?
No,
I made
I need to answer your questions, but
Oh.
if you have any comments, thoughts, or questions, please address those to Ms. Garcia or any other person that you seek legal advice from. Do you understand this?
Yes, I do, Your Honor.
Mr. Gonzalez, anything on this case?
No, Your Honor. Thank you.
Anything else, Ms. Garcia?
No, sir.
I wish all persons well. Have a good day.
Thank
Judge.
you.
Thank you, Your Honor.
Yes, sir.
Next case, Your Honor, is Attorney Marcel Knotson, page 1, number 1.
This is Tanya Elizabeth San Miguel versus Alberto Pina, cause number 2011 CVG 2217C3. Court marks Mr. Knotson present in person, Mr. Perez present in person, Mr. Raul Gonzalez present by video conference. Mr. Gonzalez is here on behalf of the Attorney General's office. Are you Alberto Pina?
Yes, Your Honor.
Welcome to court, Mr. Pina. The court marks you present in person. Are you Tanya Elizabeth San Miguel?
Yes.
Welcome to court, Ms. San Miguel. The court marks you present in person. The person to your left is your lawyer, Mr. Pina. The person to your right is your lawyer, Mr. Perez. Mr. Knotson, what is the announcement?
Your Honor, we may need a short hearing. I don't think it should take too long. We've uploaded our exhibits and we did file a request as the court advised us the last time for the drug testing. I don't know if while we're waiting, both parties can go down and have that done. There's so I don't think it should take more than 20 minutes, 30 minutes.
I have no idea.
And I'll confer with Mr.
Sure.
Pettis
the
who
hearing?
just got here. Yes.
Hopefully.
Okay.
Well, let me ask you this, Mr. Knotson. I appreciate the optimism, but if the announcement is that it's a short hearing, ostensibly, there's very few matters at issue. What are they conservatorship issues?
Yes. Basically, it's they're seeking to modify, and I don't think there's been a substantial material change in circumstances since the agreed order after mediation with Missy Gadro was entered over 2 years ago, February 7th of 2024. He's had the child since 2023.
And who's requesting the modification here?
She was. And the child she filed I guess wrote a letter. We uploaded that yesterday. I believe the court interviewed her. She gets out of school, I think at about 3:30 today. We didn't want to, she's in possession of the mom right now, so we didn't want to pull her out, but she definitely wants dad to continue to be the one that has primary, and for at most to have, under the old order, she was getting, the first, third, and fifth weekends of the month.
Let me make some observations on the record, and I think I can do this just by taking judicial notice of the court record and what was presented to the court at the last hearing. And also what Mr. Knotson just reminded the court of today. So number one, it sounds like Mr. Knotson is contemplating having a productive conversation with Mr. Perez as to how best to resolve this. And since it was told to the court that it would be a brief hearing, ostensibly there is some wiggle room, at least a comfort base to talk, number one. Number two, having now heard that Ms. Cigarro was previously involved and got the parties to a good amicable agreement, perhaps Mr. Knotson and Mr. Perez, if you talk and get to a good place, you can resolve this today. Or perhaps you would also contemplate, because what's going to happen, Mr. Pina and Ms. San Miguel, you go forward with a hearing, I'm happy to make a decision for you, but it's going to be limited by the parameters of the testimony that can be heard by the court, and that's based on relevance, on the rules of evidence and all these things. And you're not going to get to tell the court your entire story, but because it's going to be based and limited on the rules of evidence. If you talk to someone else, like Ms. Iroa, she can hear you out completely and then get you to a good place. I'm happy with either outcome, because I'm not the one that's going to live with these decisions, but have these conversations with your lawyers so that you can each make the best decision in your case. Do you have any questions, Ms. San Miguel?
Not at the moment.
Do you have any questions, Mr. Pina?
No, Your Honor.
Talk to your lawyers. This will be the first contested matter on today's docket.
I have a question. What did the court allude to reference to Cigarroa?
So if the parties are close, they should consider talking to Ms. Cigarroa at a mediation. Oh, the other thing I meant to say is, the reason I'm saying this, because it's, how old is this child?
16.
Right, so ostensibly she's in school, as she should be, and the school year is about to come to an end. So the things that you can now talk about is, where does she end and where does she go forward after the school year ends? So talk to each other and see if you can get there. If not, I'll do my best to get you there.
Thank you,
All right,
Judge.
good luck.
Thank you.
We appreciate that.
Case Your Honor is for number 9 with Attorney Andres Reyes.
This is Maria Angeles Garza versus Jaime Arturo Garza, cause number 2025 FLB 1225C3. Good afternoon, Mr. Reyes.
Good afternoon, Judge.
Court marks you present in person. Maria Garza, Jaime Garza, if you're present, please step forward.
They are both present in the courtroom, Judge.
Are you Maria Angeles Garza?
Yes.
Court marks you present in person. The person to your right is your lawyer. Are you Jaime Arturo Garza?
Yes, sir.
Welcome to court, Mr. Garza. The court marks you present in person. Mr. Garza, do you have a lawyer?
No.
Are you going forward today without a lawyer?
Yes.
Court marks you self-represented once more. Mr. Reyes, go ahead.
Judge, we are here for trial on the merits. Before coming up here, Judge, I specifically inquired of Mr. Garza with regard to whether he was gonna hire a lawyer. We've been through this several times, Judge, and the indication today was that he was not. And we had the opportunity to sit down and discuss the division of the community estate. And before I relate to the court the agreement of the parties, we can have him sworn in, Judge, so that we can take a little bit of testimony from.
Is this contested or is this a prove up?
It's a prove up, Judge. It's not contested.
Understood, Ms. Garza. Mr. Garza, I'm gonna ask that you both raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
Yes.
Both have answered yes. You may lower your hands. Mr. Reyes, one witness at a time. Go ahead.
Yes, Judge. First of all, Judge, the party stipulates to jurisdictional requirements. and that divorce should be granted on the basis of adultery on behalf of Mr. Garza. And with that, Judge, I'll ask a few questions of Ms. Garza. Will you state your name for the record?
Maria Ángeles Garza.
Maria Angeles Garza.
Ms. Garza, before coming up here, we had an opportunity to meet with Mr. Garza,
Yes.
and we discussed the division of the community estate.
Yes.
And after a lengthy discussion, we reached an agreement. Yes.
Yes.
And with regard to the community estate that was accumulated during the marriage, you've reached an agreement on each of those items. Is that true?
Yes.
The house located at 1937 Yukon Lane here in Laredo, Webb County, Texas, is
Yes.
the homestead.
Yes.
And the agreement is that that property will be your sole and separate property,
Yes.
together with all equity and debt thereon.
Yes.
And the value of the house is anywhere between $250,000. Is that true?
Yes.
And there's approximately $100,000 owed on it.
Yes.
With regard to a retirement fund that exists in Mexico by the name of Sura Asset Fondo de Retiro Mexicano.
Yes.
That is under the name of Mr. Garza. Is that true?
Yes.
Come November of this year, that fund will pay out in its entirety.
Yes.
And it is estimated that there's about $60,000 in that account or somewhere else.
Yes.
And the agreement with regard to division of that asset is that you will receive 50% of the money that is paid out.
Yes.
And Mr. Garza will receive the other 50%.
Yes.
Now, you understand that the document that will be prepared, the final decree of divorce, that it will require the translation of that document for you to provide it to the entity that's holding those funds.
Yes.
And in the agreement further is that Mr. Garza will execute any document necessary to accomplish the payment of half of those funds to you.
Yes.
Now, Mr. Garza is also entitled to receive Social Security benefits from the Mexican government.
Yes.
And likewise, it has been agreed that you will receive 50% of the Social Security benefits that will be paid to Mr. Garza.
Yes.
And likewise, it's going to be incumbent on you to translate that final decree of divorce and take it to the proper entity so
Yes.
that you can start receiving benefits from that fund. Yes.
Yes.
And Mr. Garza has agreed that he will undertake and sign any document if necessary to ensure that you do receive those benefits.
Yes.
Now, there are some vehicles that were purchased during the marriage, and the following vehicles will be your separate property. A 2011 Ford F-250.
Yes.
A 2016 Ford Escape.
Yes.
A 2015 Nissan Rogue.
Yes.
There is a 2008 Ford F-150, and that'll be the property of Mr. Garza.
Yes.
Now, inside the house at 1937 Yukon, there is home furnishings and appliances. Is that true?
Yeah.
And we have agreed that you will keep all of the home furnishings as well as the appliances
Yeah.
that are located inside that house.
Yeah.
Whatever personal property you might have in your possession is awarded to you as well. Is that true?
Yeah.
As well as whatever personal property is in the possession of Mr. Garza, that'll be awarded to him. Yes?
Yes.
Now, Mr. Garza presently lives in an RV in the Dallas-Fort Worth area. Is that true?
Yeah.
And that RV is a 2013 RV, correct?
Yes.
And that is awarded to Mr. Garza together with any equity or debt thereon?
Yeah.
Now, there's some bank accounts that have very little to no money in them. Yes?
Yeah.
And you and your husband have decided that you might maintain one open, is that true?
Yeah.
And the reason is that Mr. Garza will agree to pay the balance of the spousal support that he was ordered to pay at the temporary orders hearing in this case.
Yeah.
And we have determined there's approximately $3,500 that are owed to you by Mr. Garza.
Yeah.
And we have agreed that those $3,500 will be paid into that account.
Yeah.
And that Mr. Garza will pay that amount from the funds he receives from the Sura Asset Fondo de Retiro Mexicano.
Yeah.
And the amount will be paid in its entirety. Yes?
Yeah.
Now, there are some debts. There's a credit card under your name, advance credit card. You will
Yeah.
keep that card as your separate debt.
Okay.
And there are 3 cards under the name of Mr. Garza, American Express, the Imagine card, and a Capital One card. And Mr. Garza will keep those debts as his sole and separate debt. Yes?
Yeah.
Now, you have lived here in the state of Texas for how many years?
36.
Have you lived here in this county as well for 36 years?
Yes.
And you are representing to the court that the marriage is not, you cannot reconcile with Mr. Garza, even though you've been married for so many years.
No.
You are not requesting a name change, is that true?
No.
And it is agreed that Mr. Garza, the grounds for this divorce is based on adultery.
Yeah.
I'll call Mr. Garza now.
Mr. Garza, do you have any questions for Ms. Garza?
No.
You may proceed, Mr. Reyes.
Will you state your name for the record?
Jaime Garza.
Mr. Garza, you've been present here while I've represented to the court the agreement that we've reached in this case.
Yes.
And with regard to the grounds for the divorce, you are stipulating to the grounds, is that true?
Yes.
And with regard to the division of property, you do not have a problem with any of the items that
No.
I've described for the court.
No, agree.
You're in agreement that the 1937 Yukon Lane homestead will be Ms. Garza's sole and separate property.
Yes.
You stipulate that you owe Ms. Garza approximately $3,500 in spousal support, which was ordered by this court
Yes.
back in September of last year.
Yes.
You have agreed that you will give Ms. Garza 50% of the Sura Fondo de Retiro Mexicano and that there's gonna be a lump sum payment come November of this year
Yes.
in the approximate amount of $60,000, or if there's more, she gets 50% of it,
Whatever.
and you get 50% of it. You understand that?
Yes.
And you have agreed that from the Social Security from Mexico, that she's entitled to 50% as well.
I agree.
And with regard to the vehicles, the 2011 Ford, the 2016 Ford Escape, the 2015 Nissan Rogue, you are in agreement that she keeps those vehicles.
I agree.
And you're in agreement that you keep the 2008 Ford F-150.
Agree.
And you're in agreement that she keeps all of the household furnishings and appliances and whatever personal property she has in her possession.
Agree.
And Ms. Garza is in agreement that whatever personal property you have in your possession, together with a 2013 RV that you live in, that you keep together with any debt or equity thereon.
Agree.
And whatever property is in your possession, that will be your property as well.
Agree.
Now, with regard to the credit card debts, Ms. Garza will keep the advanced credit card, and that'll be her sole and separate debt. And you will keep the American Express, the Imagine, and the Capital One credit cards, and that'll be your sole and separate.
Agree.
debt. Did I leave anything out, Mr. Garza, that we discussed?
Mhm.
Okay, and before coming up here, nobody threatened you?
No, no.
You basically are up here voluntarily, and you sought no assistance from an attorney. You actually did consult with attorneys prior to today, but then you decided that you did not want to retain counsel, and I gave you the opportunity to go and seek one. Is that true?
Correct.
And we visited that issue several times. Is that
Correct.
true? And so you're asking the court, you're joining with Ms. Garza, asking the court to grant this divorce. Yes?
Yes.
And you're asking the court to grant the division of the community estate as I have laid it out for the court.
Yes.
And so Ms. Garza is not requesting a name change, but you are in agreement with the grounds for the divorce.
Agree.
Judge, I don't know if I left anything out, but I think I didn't.
4 questions. First question to Ms. Garza, 2 and 2. Ms. Garza, do you have any minor children with Mr. Garza?
No.
No.
You've told the court about your agreement regarding the division of your property. Do you believe that that agreement is a just and right division of your property?
Yeah.
Mr. Garza, Ms. Garza told the court that you and her would like to be divorced on the grounds of adultery. Is that your understanding?
Yes.
The court heard from both and each of you about the division of your property, that agreement that you have. Do you believe that that agreement is a just and right division of your property?
Yes.
All right. Mr. Garza, Ms. Garza, in your case, cause number 2025 FLB 1225C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage. Unfortunately, that marriage has become insupportable due to a discord or a conflict of personalities that destroy the legitimate ends of the marriage relationship. The court finds that there are no minor children of the marriage, none are adopted, none are expected. The court has heard your agreement regarding the division of your property. The court hereby adopts and approves your agreement in full and finds that it is a just and right division. The court at this time finds that there is no reasonable expectation of reconciliation. The court grants the divorce on the basis of adultery, and the court hereby pronounces and renders you divorced. These are the orders of the court, and the orders are due to the court on or before
May 18th at noon by submission.
That concludes your case here. Ms. Garza, do you have any questions for the court?
No.
Do you have any questions for the court, Mr. Garza?
No.
I wish you both very well. Have a good day.
Judge, I have nothing further, Judge. May I be
It's
excused?
good to see you, Mr. Reyes. Have a good day.
Always good to see you.
Thank you.
Next case, Attorney Omar Villarreal, page 6, number 17.
Susana Lee Castillo versus Miguel Angel Rangel, cause number 2026 FLG 617C3. Good afternoon, Mr. Villarreal.
Good afternoon, Your Honor.
Court martial present in person, I'll just put on the record, no relationship to the court. Are you Annalie Castillo? Welcome to court, Ms. Castillo, the court martial present in person. Am I pronouncing your name correctly?
It's Anayeli.
One more time.
Anayeli.
Anayeli Castillo, welcome to court, Ms. Castillo. Are you Miguel Ángel Rangel?
Yes, sir.
Welcome to court, Mr. Rangel, the court martial present in person. You may lower your hands. Mr. Rangel, do you have a lawyer? Court has heard no. I need you to pull the microphone as close to your mouth as possible when you respond. And that's not for my benefit, but for the record. Everything is being recorded, and I want to make sure that we have a good and accurate record. Mr. Rangel, do you have a lawyer?
No.
Will you be going forward without a lawyer?
Yes, sir.
Court marks you self-represented. Ms. Flores, does the court have Mr. Rangel's email address?
No, Your Honor.
Mr. Rangel, what is your email address?
Ahorita no tengo uno conmigo.
You don't have one with you, or you don't have an email?
¿No tienes correo electrónico?
I don't have one. Court has heard. Mr. Rangel doesn't have an email address. Mr. Villarreal, go ahead.
We have an agreed protective order. I have a copy of the protective order. I don't know if you want to copy.
Hand it to the clerk, please. Ms. Castillo, Mr. Rangel, I'm gonna ask that you both raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth to help you God?
Yes.
Yes.
You may lower your hands. Is your true and correct name Anayeli Castillo? Ms. Castillo, the court has been handed a signed protective order. Did you sign this protective order? Is that your agreement with Mr. Rangel?
Yes.
I'm asking her questions. Hold on. Is that your agreement with Mr. Rangel?
Yes.
Is that your full agreement?
Yes.
Was anything left out? Is there anything you want to change? Then everybody,
Inaudible. Answers have been inaudible.
we're gonna have to start all over again. I need you not to move back and forth, but speak very loud and speak right in front of the microphone. Pull yourself as close to the microphone as possible. One more time. You are under oath. Is your true and correct name Anayeli Castillo? Ms. Castillo, the court has been handed an agreed to protective order. Is this your agreement with Mr. Rangel?
Yes.
Is this your full agreement?
Yes.
Was anything left out?
No.
Is there anything you want to change?
No.
Has anybody forced you or coerced you into entering into this agreement?
No.
Same questions to you, Mr. Rangel. Is your true and correct name Miguel Ángel Rangel?
Yes.
Mr. Rangel, the court has been handed an agreed to protective order signed by both you and Ms. Castillo. Is that your signature?
Yes.
Did you enter into this protective order agreement voluntarily?
Yes.
Is this your agreement with Ms. Castillo?
Yes.
Is that your full agreement?
Yes.
Is there anything you want to change?
No.
Does anybody force you or coerce you in any manner to enter into this agreement?
No.
Right. Anything else for the record, Mr. Villarreal?
Nothing further, Your Honor, just to let you know that there's 3 kids they have in common, and that's why the box of the communication wasn't checked, because they're gonna have to be able to communicate regarding the custody of the kids.
All right. Ms. Castillo, Mr. Rangel, in cause number 2026 FLG 617C3, the court has signed off on your agreed to protective order. Mr. Rangel, you are now prohibited from committing any acts of family violence or any further acts. You can't communicate in a threatening or harassing manner. Ms. Castillo, you can't do that through any other person either. You can't do it, but you can't cause any other person to do that. You can't go within 200 yards of her or her residence or her place of employment. You can't engage in any conduct that is reasonably likely to harass, annoy, or alarm, abuse, or torment, embarrass her in any manner or fashion. You can't transfer, encumber any property that you mutually own together. You can't track or monitor in any form or fashion whatsoever. And you can't own, possess, buy, or attempt to receive any firearm parts or ammunition. And you can't dissuade her or prevent her from coming to court or testifying in any way. Do you understand all of these things?
Yes, sir.
Do you have any questions on any of this?
No, sir.
The court has signed off on that agreed to protective order signed by both parties, and now the court is tendering the original to the clerk's office. Ms. Castillo, do you have any questions for the court?
No, sir.
Mr. Rangel, do you have any questions?
No, sir.
Anything else on this case?
Nothing further, Your Honor.
I wish everyone well. Have a good day.
Thank you, Your Honor.
Next case, Attorney Rene Cantu, page 3, number 8.
Miguel Angel Cuenca versus Brenda Marie Cuenca, cause number 2025 FLA 1624C3. Court marks Mr. Raul Gonzalez present by video conference on behalf of the Attorney General's office. Miguel Cuenca, I'm going to ask that you unmute your device. Are you Miguel Cuenca?
Yes.
Welcome to court. The court marks you present. You're participating by video conference. Also present is your lawyer. He's present in person. Brenda Cuenca, Nathan Chu, are you present? Into the microphone, please.
Yes. Good afternoon, Your Honor. I'm here for Mr. Cuenca, Your Honor. I know that,
Hello, good afternoon, Judge.
I'm sorry, what is your name?
he's my other client, Judge.
There's a motion for continuance, Mr. Cantu.
Right, I had, told Mr. Chu that I was gonna talk to my client, Judge, about, whether or not to go forward because my client is just, he needs to get this case over and done with, Your Honor. So I wanted to talk to him to see if, he would oppose it or not, and talk to Mr. Chu, see if we can have an agreement, Your Honor, because we kind of want to finish today, Judge. So what I was gonna ask the court is, can the court just put me on recall? My other case, I do have an agreement with the opposing counsel, but I would like to talk to Mr. Chu and see if we can get this done today, Judge.
Talk to Mr. Chu. This was filed today, 12 minutes before we were supposed to start, and
Right, sir, and that's why I, you know, and he knows, Judge, we're ready to, I had sent several offers that I thought were very reasonable, so I'm not, I don't know what the delay is, but I would like to talk to Mr. Chu, Judge.
all right. Without knowing anything else, let me place this case as the second contested matter on today's
Yes, sir.
docket.
That'll
All
work,
right.
Judge.
Mr. Cuenca, stand by, please.
Mr. I have another matter on page 5, number 13.
Cindy Guadalupe Lopez versus Zenobio Lopez Jr., cause number 2026 FLA 599C3. Court marks Mr. Cantu present in person. Mr. Rodolfo Santos, are you present?
Good afternoon, Your Honor. Present and ready.
Court marks you present and participating by video conference. Are you Zenobio Lopez Jr.?
Yes, Your Honor.
Welcome to court, Mr. Lopez. The court marks you present in person. The person to your right is your lawyer. Are you Cindy Lopez?
Yes, Your Honor.
Welcome to court, Ms. Lopez. The court marks you present. You're participating by video conference. Counsel, what is the announcement?
Your Honor, like Mr. Cantu mentioned, the parties did confer and we've reached an agreement on all terms with regard to temporary orders. And with the court's permission, we would like to read that agreement into the record.
Yes, sir. Go ahead.
Your Honor, the parties have agreed that they're going to be temporarily named joint managing conservators of the child the subject of the suit. Ms. Cindy Lopez is going to have the exclusive right to designate the primary residence of the child. There is going to be included a morality clause stating that no unrelated adults will be kept in the same place as the child from 10 p.m. to 8 a.m. while each conservator respectively has possession of the child. They've also agreed to include a right of first refusal in the event that either party is going to be absent for at least 4 hours. They're going to give the other conservator an opportunity to take possession of the child. Mrs. Lopez will continue to have the exclusive use of the marital home. Mr. Lopez will be paying for the mortgage, all utilities, services, and expenses at the home. He'll continue paying for car insurance, credit card debts, loans, and I believe, I don't know if I'm missing anything with regard to debts, but I believe that covers all the debts. There's not going to be any child support ordered at this time, but this in no way will prevent or hinder us from later on seeking retroactive for the months that the divorce has been filed. I believe that that is the extent of the agreement at this time, Your Honor, unless I might have left something out.
Mr. Cantu.
Your Honor, I believe Mr. Santos is correct. We have conferred, we've addressed everything. My goal is, as Mr. Santos's goal is, we just want to get the parties through this legal matter amicably, Judge. They both have very good jobs, Judge. They both work for the city, and they're good parents, Judge. Both of them are very good parents. So I think we can get there, Your Honor. I think Mr. Santos and I have a very good working relationship. We'll be able to work this case out, Your Honor. There is a final trial date set for July. So our goal, Judge, is to continue working with Mr. Santos, and I think we'll be able to have a finalized decree for you in July, Judge.
Understood. Several questions, Mr. Santos. How many children before the court?
There's one child that's subject to the suit, Your Honor.
Age?
3.
Gender?
Male.
All right. Ms. Lopez, Mr. Lopez, I'm going to ask that you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
Yes, Your Honor.
Both have answered yes. You may lower your hands. I'm going to start by asking you, Ms. Lopez, you're the petitioner in this case. Is your true and correct name Cindy Guadalupe Lopez?
Yes, sir.
Welcome to court once more. You're joining us by video conference, as is your lawyer. Ms. Lopez, did you hear and understand the agreement that was told to the court by the lawyers?
Yes, Your Honor.
These are only temporary until you come back to a trial on the merits on July the 9th, 2026 at 2. But for temporary orders, is this your agreement with Mr. Lopez?
Yes, Your Honor.
Is this your full agreement right now?
Yes.
Was anything left out?
No, sir.
Is there anything you want to change?
No, sir.
Do you believe that this agreement is in the best interest of your 3-year-old son, at least temporarily?
Yes, sir, I do.
Same questions to you, Mr. Lopez. Is your true and correct name Zenobio Lopez Jr.?
Yes, Your Honor.
Welcome to court once more. You're joining us in person. The person to your right is your lawyer, Mr. Lopez. Did you hear and understand all of the agreement that was told to the court by the lawyers?
Yes, Your Honor.
Is that your agreement with Mrs. Lopez?
Yes, Your Honor.
This is only temporary until you come back for final hearing in July, but at least temporarily, is this your full agreement with Ms. Lopez?
Yes, sir.
Was anything left out?
No, sir.
Is there anything you want to change?
No, sir.
Do you believe that this agreement, at least temporarily, is in the best interest of your son?
Yes, sir.
The court hereby adopts and approves your agreement in full, finds that this agreement is in the best interest of your son. These are now orders of the court, and the orders are due to the court on or before
May 18th at noon by submission.
That concludes your case for today, Ms. Lopez. Mr. Lopez, these matters are always very hard, but it's always refreshing when persons can talk to each other respectfully, at least through your lawyer. So you've gotten through at least a very difficult part already. Mrs. Lopez, do you have any questions for the court?
No, Your Honor.
Do you have any questions, Mr. Lopez?
No, Your Honor.
I wish you both very well, but more importantly, I wish your son all the best.
Thank you, sir.
Have a good day.
Thank you. Thank you.
Your Honor, that's all I have for the court today. May I be excused, Your Honor?
Yes, sir. Have a good day. Good to see you.
Good to see you as well, Judge. Thank you.
Yes, sir.
Next case, page 5, number 12, with Attorney Brenda Anderson.
Iris Bisana versus Andres Alejandro Ramon, cause number 2026 FLA 131C3. Ms. Anderson, are you present?
Yes, Judge. Good afternoon. Brenda Anderson, present for Edie Pisana.
Welcome to court, the court-martial
Oh,
present.
sorry,
You're
when-
participating.
There we
That's
go.
why I didn't see you. Very good. Welcome to court, the court-martial present by video conference. Iris Bisana,
yes.
Andres Ramon, are you present?
Yes, sir.
Are you Andres Alejandro Ramon?
Yes, sir.
Welcome to court, Mr. Ramon, the court-martial present. You're participating by video conference. Mr. Ramon, do you have a lawyer?
No, sir.
Are you going forward without a lawyer?
Yes, sir.
The court marks you self-represented. Ms. Flores, does the court have Mr. Ramon's email address?
No, Your Honor.
Mr. Ramon, what is your email address?
Cadena Logistics 316 at outlook.com.
One more time, a little bit slower to make sure that we got it. One more time, go ahead.
Yes, Cadena Logistics 316 at outlook.com.
All right. Are you Iris Pisana? I'm going to ask that you unmute your device. There is
Yes. Yes.
You are Iris Pisana?
Yes.
Court marks you present by video conference. As you can see and hear from your device, your lawyer is also present by video conference. Ms. Anderson, go ahead.
Your Honor, this is the first setting on this case. I am requesting some time so that I could get some information from Mr. Ramon if he's going to be proceeding without an attorney. There are children, so we do need to work on child support. So I'm asking if the court could set us up for a final pretrial and a TOM and for a final hearing date.
You get some background facts so that I can give you the best, each side, the best outcome. Mr. Anderson, how many children before the court?
There's one minor child.
Age?
Age 12.
And gender?
Female.
All right. Ms. Pisana, your lawyer says you have one child, a 12-year-old daughter with Mr. Ramon. Is that true?
Yes.
All right, Mr. Ramon, Ms. Anderson is requesting some additional time because there's certain information that she needs to get from you. I'm about to order that, but Mr. Ramon, are you employed?
No, sir.
You don't work?
No, sir, not at the moment.
How long have you been without employment?
I've been without employment. I'm going for a month.
And before your unemployment, what were you doing?
I was unemployed. I was on unemployment for 6 months and a half. I was living in California, and I was actually looking for a job.
You've been unemployed for one
I'm on
month, and before that, you were unemployed for 6 months?
Yes, because I was actually not here in Texas. I was in California for 6 months, and then I came to Laredo on January, and then I got a job on last month, and I was there only for 2 weeks and a half.
Let me ask you this, Mr. Ramon, when was the last time that you were regularly employed?
Regular employee, it was on July of last year.
And how long were you at that position or location?
I was there for 7 months.
Have you filed your 2020
No. I think se congeló la pantalla, no se ve bien. Miss Anderson?
Yes, I think Judge, I think you froze. Yes, I agree, Mr. Ramon.
Yes. Le voy a quitar los headphones. Permíteme tantito.
Say that again?
I'm gonna remove my headphones.
Okay, just hold on until the judge connects back.
¿Me escuchó?
Sí.
Perfecto. Sí. Bueno, no sé si nos esperamos al juez, pero tengo una pregunta para usted, Miss Anderson. ¿Quiere hacer una cita en persona para las preguntas que usted tiene para mí?
Le voy a hablar por teléfono primero, ¿ok? O se lo voy a mandar por correo electrónico.
Sí.
Las preguntas para que me pueda
Sí.
contestar así, ¿ok? Pero ahorita vamos a esperar al juez.
Sí, claro. Sí, está bien. No hay problema.
Good afternoon, council. This is Tuesday, April 28th, 2026. The time is now 3:35. I'm talking to you from Chambers. I regret to inform you that there is a county-wide internet outage, and I don't mean county-wide Webb County, I mean the governmental entity. AT&T is down. So let me call out some names. I see that the following lawyers are logged in and present. Oscar Vela, Leticia Garcia, Marilyn Lopez Escoto, Ruben Arce, Javier Guzman, Julia Rubio, Brenda Anderson, and Juan Jose Garcia. Is there any lawyer or attorney whose name I have not called? Russell Jordan, I see that you are also logged in. Is there any other person whose name, any other lawyer whose name I have not called? All right. Can somebody give me some affirmation since we can't log in? I'm logging into you from one of the staff.
I heard you, Judge.
We can
All
hear
right.
you.
Yes,
Thank
Judge.
you. All right, folks. If there's no other lawyers logged in, I'm giving you, and I can't even do anything right now because I can't even court record at this time. So I'm going to reschedule all of the cases that have not been heard or called. I'm going to schedule that for May the 5th at 10 a.m. We do have a 2 p.m. setting for the family law docket in any event. We have a 9 a.m. criminal law docket that I suspect will be close to finishing up by that point. I wish things were different. Does anybody have any questions?
I guess, Judge, for me, one was a non-suit and one was the entry of the decree. Can I just advise your staff that those things have been done so that way they can take me off the docket?
That would be perfect. Yes.
Okay, okay, all right.
Miss Flores is next to me taking notes, so she's on it already.
Okay, perfect. Thank you, Judge. May I be
Thank you.
excused?
Yes, have a good day.
You too. Stay safe. Have patience.
Thank you, Honor.
Does any other person here have any questions?
Well,
You'll
Judge,
be receiving reset notices May the 5th at 10 a.m. Mr. Arce.
if I may, Judge, I don't want to put the court out, but mine was going to be an announcement. Your Honor, we were waiting on some documents from the state of Texas that were still going to take a while. So on the 5th, we'd probably ask for more time. I don't know if there's a later date, Judge.
I don't know the answer. I don't have access to any of that stuff right now.
Understand.
The best thing I can tell you, you can either appear on that date and put that on the record because none of this is on the record, or you could just file an advisory with the court making that same request. That way, I'll receive it beforehand and I'll be able to rule on that beforehand.
Yes, Judge.
But great question.
Thank you,
Thank you.
Judge.
Thank you. Thank you.
Thank you.
Yes, if
Thank
there
you,
are no
Judge.
other questions from the lawyers, if you have no questions, you may log off and we'll see you on May the 5th at 10.
Okay, thank you.
Thank you,
Thank
Judge.
you.
Thank you, Your Honor.
Does
Judge
any
Villarreal?
other person have any questions?
Yes, Your Honor. Raul Gonzalez here with Office Attorney General. Quick
Yes, sir.
question regarding the 2 contested matters that were yet to be heard, Your Honor. Are they also going to be rescheduled on May 5th?
Yes, they are, because even though they're in person, Zoom is one of 2 ways that we use to court record. Actually, one of 3 ways, and we don't have access to 2 of those without. We can't court record right now. So
Yes, sir.
anything that hasn't been heard yet or finalized today is reset to. I can't even take announcements. So May the 5th at 10 a.m.
Perfect. Thank you, Your
Good
Honor.
question,
Have a good
Mr.
day.
Gonzalez. Thank you. Have a great day.
Yes.
Does any other person have any questions?
Yeah, Your Honor.
Yes, sir.
Yeah, it's Gabriel Juarez. There was going to be an issue with because today's my final court hearing, or it should have been.
Right.
The only thing is that the ad litem that was appointed, she had actually withdrawn herself because there was a payment issue from the other party on the other party's behalf. I mean, I'm aware there's not much you can do. You know, your hands are probably tied right now, but how would I, knowing that's a problem right now, and it's been a problem, I don't want it to be, you know, May the 5th, and I tell you the same story. Oh, there's no ad litem. So, what can I tell my attorney? Because I'm not sure if he's logged in.
I am told, I mean, I don't see him anymore, but
It was
I was
Russell
told
Jordan.
that Mr. Russell Jordan was logged in, so he should have heard that announcement. If not, reach out to him. Reach out to him, let him know. But you're not going to be in a better place or a worse place. You're just going to be in the same place. You know, I know that that may not be much solace, but you're not going to be any better off or worse off on the 5th than you are today. So talk to him. Perhaps he may want to consider filing something in advance of that setting on May the 5th.
All right. Got it. Thank you.
All right. Thank you, Mr. Juarez. Be safe.
Likewise.
Take care.
Likewise. Thank you. Bye.
Does any other person logged in have any questions? All right. I wish all person well. This concludes our docket. Have a good day.